ndị be anyị okwu DNA alịpụtawagokwa n'ọzọ ụnụ anụkwalụ na iwu Naijiria marakwa ihe bụ na eji DNA achọpụta onye nwe nwa. Nke anụnwa bụ ihe si n'ọnụ onye ọkaiwu akpọrọ Stan Alieke. Ọ bụkwa na onye ọkaiwu nọ n'Abuja wee na-alụ nke ụnụ ga-abịazi n'ihe ọ kọrọ maka DNA test ya na iji wee chọpụta onye nwe nwa n'obodo abụ Naijiria na ihe iwu nyelu n'obodo abụ Naijiria. Nwanne ọ bụrụ si ijuri ga-agwa unu nke a, ị ga-anụ ya n'ọnụ ya kpọmkwem maka na ndị kwe na ndị ekwere karịrị na ngalaba okwu ebe ihe onyonyo asị.
After the death of the popular late singer Mohbad, I'm sorry that mentioning his name, I just have to read so as to provide clarity and context to the discussion. There have been a series of court cases surrounding his death, and one of the cases in court is for the court to determine whether his son is actually his true son or not, his legitimate son or not. And the court have ruled for the adoption of the scientific method known as DNA. Now, the purpose of this, the court trying to determine, or people trying to know if boy is actually the son of the father, is to know if he is legitimately presumed or be presumed to be his next of kin. Now, when he becomes the next of kin, that means every asset, every wealth, every estate of the father, the late father, will be bequeathed on him, on his son, as his next of kin, in accordance with the provisions of our law. Now, there has been a public divide as to there must be a DNA or there must not be a DNA. We have to, the public must know or what not. But unfortunately, contrary to what the public opinion or what people may know, the scientific method known as DNA is not recognized in any of our laws as a way of proving or determining the paternity of a child. In fact, there's no way in our laws that is provided that for you to determine the paternity of a child, DNA must be conducted. No. But what is provided in our laws is that any child that is born at the course of a marriage or during the time that marriage is existing or subsisting is presumed to be the child of the man or to be the son or daughter of the father. Now, even when the marriage has been dissolved, if the child is born within 280 days, this is provided in section 165 of the Evidence Act, within 280 days after the marriage has been dissolved, that child will still be presumed to be fathered by the man or by the father. Now, the court have also noted the customary practice or some of the customs and traditions in Nigeria. In fact, the Supreme Court have noted that in the Yoruba custom, if a man have accepted the pregnancy of a woman or have publicly acknowledged the child to be his own, that child will automatically become or will presume to be the child of the man. Now, if the man also allow the child to take his last name, if the man conducted the naming ceremony of the child, it doesn't matter if the boy or the daughter is a legitimate child of the man, he will be presumed, legally be presumed as the son or daughter of the man, and every right that follows the child, legitimate child, will be accorded to that child. Same thing goes with the Hausa Fulani customs, as the court have noted, that any child that is born at the course of a marriage, or any child that has been publicly acknowledged by the man to be his child, or any child that has taken the last name of the man, will be presumed in law to be the child of the man. It doesn't matter if the DNA result says otherwise. Now, the Igbo custom takes a different approach to this, right? Now, what determines the paternity of the child in accordance to the Igbo custom is the payment of a bride price of the woman. Now, let's say if a man pays the bride price of the wife, every child that is born, whether out of wedlock or during the course of the marriage, will be presumed to be the child of the man. Now, the child that is born out of wedlock, or a child that the father is yet to pay the bride price of the mother, will be presumed to be fatherless. That is the provisions of the Igbo custom that has been noted by the court. Now, these are the things that determine the paternity of a child, and not DNA. DNA is only foreign to our laws. In fact, DNA in court is treated as a secondary source of evidence. The primary source is what has been noted by the court. First, was the child born at the course of the marriage? Secondly, has the man publicly acknowledged the child to be his own? Thirdly, did the man allow the child to take his last name? As for the Igbo custom, has the man paid the bride price of the wife or the woman? If the man has paid the bride price of the woman, then every child that is born, either be it out of wedlock or during the marriage, we presume to be fathered by the man.
Ndị be anyị unu nụrụ ya n'ọnụ ya na ọ sịrị na iwu Naijiria o nwere ihe gbasara ya na DNA test nọ ihe obodo kwutelu bụ ihe fama maka ya. Unu nụrụ ka o si wee kọwazie anya kọwaa nke ndị Hausa, nke ndị Fulani, nke ndị Yoruba na nke ndị Igbo. Nwanne ọ bụrụ n'ọnụ m ka o si ijezie na ngalaba okwu ndị adọla onwefa ndị kwe ma ndị ekwe na karịa ma ndị sịrị ehe na fa kwuru ekwu na ya bụ ife bụ eziokwu na ihe o kwuru bụ otu o kwesịrị isi dị n'ọgbaga m onye ọbụla na-ekwu nke ụfọdụ wee sị mana ime agbamakwụkwọ bụ nke ndị ọcha mana ndị Naijiria na-eme kedu ife ọ na-akọzi ụfọdụ si ya si jee mewe DNA ebe ụfọdụ sịrị mba kwa na o nwere ihe gbasara Naijiria na DNA nwanne akụkọ ọkarịrị kedu ebe ịkwụ na ya iso na ndị kwe ka iso na ndị ekwerọ nwanne denye nke gị na ngalaba okwu maka na ike nsịcharịa dịrọ m n'ime ihe niile na m ga na-ekwurịtakwa n'udo ga na-achịrị ka udo chianụ ndị nke m maka ndị chọrọ udo